with a low standard of review. It is for the public to make this decision. You said earlier, and I'm from out of the county, I don't understand what's happening with the underlying project proposal, but we're not here to talk about that. We're about whether this statute and its low standards allow the petitioners to do what they're trying to do.
I appreciate it. All right, I'll give you about a 1 minute. Do you have anything else you want to say?
Your Honor, all we can respond to is what is stated in the petition itself. The only time it mentions the accountability report is in allegation number 3, which is, it doesn't provide the specificity to comply with the statute. The recall statute says you have to identify specific acts that support your allegation that something is misfeasance, malfeasance, or a violation of the oath of office. The auditor's report, they don't identify what it is that is alleged to be violated there. And now, at argument, we're confronted with more specificity. It has to be in the petition. If it wasn't in the petition, we have no basis to respond to it. With regard to the case law, I think that our Supreme Court has said regarding the Open Public Meetings Act and the Pearsall-Stipek case especially, is that it has to be an intentional violation of the Open Public Meetings Act. You're dealing with non-lawyers who are elected commissioners. And the Open Public Meetings Act itself recognizes that in order to have them personally responsible, it isn't just a intentional action. They intended to go into an executive session. It has to be more. It has to be knowing violation. The Open Public Meetings Act itself makes individuals liable only where there is a knowing violation. So to recall somebody from their elected position, to overturn the result of an election, it's not the slow standard. It has to be a clear evidence of misfeasance, malfeasance, or improper conduct that violates someone's oath of office. And that just hasn't been shown.
Your Honor, I'd like to cite an improper reading of the law that respondents just referred to. It is squarely addressed by the court in Cass, the Washington Supreme Court decision, saying courts look also to supporting evidence attached with the petition to determine whether the petition is sufficient. That's Cass 144 WN2D at 814.
This is a petition to determine the sufficiency of recall charges and to approve it for ballot. In reviewing it, there were 8 specific allegations. I will start and go through those specifically. I do agree with you, Mr. Dockers, that it's not for this court to decide what, if he should be recalled, but just is there enough evidence to put it on the ballot for the people given it. In the first one, allegation, is the motion to retain audio recordings for 2 years, but that was voted down. And then the subsequent, and that was in the June meeting. Then subsequently, which he in fact did do, Mr. Hupp did vote for a 6-year retention because that is the retention law as seen. I do not find a factual or legal sufficient basis for allegation number 1 or number 2 to put this before a vote of the voters of Mason County. I believe that a failed motion to preserve recordings, he may not have known what the state law requires, but it was a failed motion. And then when in fact he voted in the proper form in unanimously adopting resolution 1003, I see nothing here factually or legally to put this before the vote. number three is an allegation of repeated violations of the Open Public Record Act, stemming from a series of emails. The specific emails as alleged are May 29th, 2010, June 18th, 2010, and July 31st, 2010. The receipt is, all three are insufficient to me, factually. They do not purport to be a repeated pattern of violation of the Open Public Meetings Act. And therefore they are legally insufficient in and of themselves, not in and of themselves as each of them on that date, or as a whole, taking the three as a whole would not constitute that. Allegation 4, as to handling the potential overflow crowd as seen in the August 3rd, and then using the speakers in the tent on the August 16th meeting to accommodate all attendees. I think that is entirely within the discretion of the chairperson, and it was a discussion on August 3rd as to how to implement it so that everyone may be heard. I think it's factually and legally insufficient to put forth a recall petition. Number 5, again, is the email on July 31st in violation of the resolution and delegation of authority. I just don't see it. Therefore, I find that is insufficient. Number 6 is the public records request for Mr. Huff's personal cell phone records. Again, I talked about that. This, in and of itself, cannot come before the court in this manner, as I do not see them to be public records. Second of all, this is not a public records request. This is a recall petition. The violation of his oath of office, that he invited people into the August 16th executive session, and also that the meeting minutes do not accurately describe the port business as recorded on the tape of the meeting. I would agree with you that the meetings minutes are vague, are small. We discussed interests of what is of other jurisdictions. But there is nothing in the meeting minutes that do not accurately describe what the port did, and it is factually insufficient. There is nothing in RCW 4230-080 that requires how detailed minutes must be kept. And therefore, it is insufficient factually to legally support. Therefore, I have no choice on all 8 matters as to dismiss this petition at this time. I find all 8 very specific charges are insufficient factually and legally to support a petition for recall. Further, there is a request for CR 11 sanctions. I will not allow them at this time. I believe that your petitioners acted in good faith to bring this. I believe that they have a right to do so. And it may not be what the outcome is they wanted, but I believe that they had specific information enough that I do not look to CR 11 sanctions at this time. Is there anything else to come before the court?
No, Your Honor, I have actually prepared an order.
I'm going to ask you to refer to that, counsel. Does the prosecutor want to see that order?
I was going to inquire if the court wished to have the county draft findings and conclusions, but we have an order.
I'm not sure that findings and conclusions are required. If they are, we certainly can prepare them and present them at a later date.
I went through all 8 allegations, and I believe it is on the record. If you wish to draft them for appellate purposes, but I'm going to sign an order. You have 30 days in which to appeal. If you do not appeal, it is forever waived. Also, Mr. Meyer, you have 30 days in which to appeal my denial of CR 11 sanctions. And if you wish to do so, you may do so. But both sides are going to be given their 30 days, and I'm signing an order today.
Theresa, can I come up with you?